Welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. My name is Chris Davis, and I'm a partner with Weber Gallagher, and I handle Pennsylvania workers' compensation cases out of the Philadelphia office. And I'm presenting today with Jeff Lockyer, one of my partners who does both Pennsylvania and Delaware law from our Philadelphia office. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage your risk in your business. If you'd like to view this webinar again, share it with others, or see our other Weber Gallagher University programs, please visit the Weber Gallagher website, www.weberwglaw.com, and you will find copies of this presentation and others under the Weber Gallagher University page. Also, feel free to contact the firm with any questions at news@wglaw.com. So today's presentation is called The Effective Use of Pennsylvania Court System to Settle Cases. Next month, we're going to be doing a topic called Sloan versus Workers' Compensation Appeal Board, which discusses the evolving case law surrounding the issuance of what happens legally when you issue a medical-only NCP, and explores certain statute of limitations issues associated with medical-only NCPs. So with that, we'll start the seminar, and I'll turn it over to Jeff to talk about kind of how we set up the PowerPoint for today and what to expect.
Good afternoon, everybody. Thank you for joining us. So what we're going to do is kind of walk through what you use to settle a case in Pennsylvania, how you settle it, and then how you get it approved. Once we've covered sort of the foundation, then we can move on a little bit to the types of issues you're going to run into either while you're in the negotiation phase, trying to settle the case and make sure you get all the terms you need in your settlement. And then we're going to talk about some of the obstacles or issues you may run into while you're trying to get it approved by the court. That's basically how we're going to proceed today.
So just from a historical perspective, in Pennsylvania, up until 2006, we were not able to settle workers' compensation cases. We had to do what was known as a commutation, but we weren't able to fully settle indemnity, medical, and other issues associated with the case. Since Act 57 came into being in 2006, we now have the ability to settle past, present, and future indemnity, medical benefits. We can settle death benefits, and we can settle disfigurement and specific loss cases. So we now have the ability to settle cases. The next question becomes, how do we do that?
So in Pennsylvania, the settlement document is an actual bureau form. It's LIBC 755, and it's called the Compromise and Release Agreement. So every settlement in Pennsylvania is going to use this document. If it doesn't, it's not a binding settlement in Pennsylvania. The CNR agreement will have sections for you to include all of the terms of your settlement, the amount, what you're agreeing to, what you're settling, what you're not. You can use it to settle just wage loss. You could use it to settle just medical. You could use it to settle everything. But that is what you're going to use. The thing that is most important about the actual CNR agreement is that the settlement is only binding once that CNR is approved by the court. The fact that you've reached an agreement with the other party, the fact that you've completed all the paperwork and everyone signed it, that's not sufficient. In Pennsylvania, you have to do all of those things and then have the court approve it.
So Jeff, if you have a claimant or an employer who enters into a compromise and release agreement and completes the paperwork, the LIBC 755 form, and something happens before the hearing, can they pull out?
They absolutely can. This, unfortunately, happens fairly frequently. There's no mechanism to enforce a workers' compensation settlement if it hasn't already been approved by the court. It's really just an agreement in principle before you get that order.
And then settlement is only binding after judicial approval, and what happens is the claimant has to typically go in front of the judge live, and the judge asks them a series of questions, and both parties ask a series of questions, and then ultimately the judge will either approve or disapprove of the agreement, right?
That is correct. That is correct. So, Chris touched on the fact that we need a hearing. We need to have the claimant testify as to what he understands. How do we get our settlement in front of the court so we have a hearing? Well, if you have a case that is in litigation, you have a claim petition, termination petition, something already pending, then you are free to contact the court and just say, hey, we'd like to come in for a settlement hearing, and you can amend your current petition to a CNR. There's no additional filing needed. A lot of times you'll want to expedite getting the case settled, so you'll contact the judge and say, our hearing's in June, can you get us in next week? And a lot of times they can accommodate you, but there are times that the court is booked and can't get you in for a deadline. And then, Chris, what do you do when you get stuck in that situation?
Right. So in some jurisdictions, Philadelphia in particular, the judges have a very large caseload, and they're not able to accommodate the request. So you might be waiting 30 days, 45 days to get a CNR hearing date. The problem comes up is when the claimant is on repetitive pay and you want to move that case and you want to close that case. So what the Bureau did is create what's called resolution court, and it's in 131.60 of the judge's rules. And basically it calls for being able to contact the sitting judge and asking that the CNR be placed into resolution court. It usually gets assigned to another resolution court judge, and they're required to hold a hearing within 14 business days, and also they're required under the judge's rules to issue a decision within 5 business days. So utilizing resolution court in some situations is a good way to handle the case if you really want to expedite it and move it.
Chris, can you use resolution court if you don't have a petition already in the court system?
No, you need to have a petition currently pending in the system. So that's one of the limitations. But if you do have a petition currently pending, resolution court is a good option for you.
Okay. And so, what do you do when you don't have a petition pending? You can't amend it. You can't use resolution court. What you do is you file a compromise and release petition. So the only downside of that is it has to be assigned and you have to get your hearing date, but it's generally pretty quick. And that's really the avenue available to you if you don't already have litigation.
Right.
So we've talked about needing a hearing.
So Jeff, what happens actually at one of these workers' compensation CNR hearings?
Okay. So what will happen at this hearing is that the parties will all be present. You'll bring the executed paperwork, or you'll have it signed while you're at the hearing prior to your case being called by the judge. But the main thing that's going to happen is the claimant is going to testify. He's going to testify on one thing, and that is his understanding of the agreement. Not it's a good deal, it's a bad deal, not why he's entering into the settlement agreement. Just does he understand what he's giving up and what he's getting in return? And that could entail in questions from just his attorney, from defense attorney and claimant's attorney, and also the judge. And each judge is going to handle procedurally the hearing differently. So you might have a judge that asks all the questions that are relevant and doesn't want to hear much from the attorneys unless there's something very specific about your settlement that needs to be asked that the judge didn't cover. You may have judges that stay completely out of it and expect the attorneys to cover everything that's relevant. So all the judge is legally supposed to be considering is this a settlement that the claimant understands? They're not supposed to be saying, is this a good deal, bad deal, I don't think it's fair to the claimant. No, it's did the claimant understand it? And what you'll find in Pennsylvania is that each judge does things differently. In addition to their procedures being different, they're going to approve different types of things in their settlement. Some judges may allow you to do X, Y, and Z, other judges may not. So you need to know which judge you're in front of if you have something a little bit tricky or a little bit complex about your settlement, so you know you're going to get it through.
Right, and it's interesting. I mean, you know, Jeff mentioned about the judges differing. Some of the CNR hearings are very short. Some of the judges' CNR hearings can last 20 to 30 minutes. So it all depends on who your judge is and what their procedure is.
And there are actually a few outliers out there that will require you to send the paperwork to them executed before the hearing. That's very rare, but again, you just have to know your judge.
Jeff, what are the types of things that you want to make sure that you address at the time CNR hearing?
Well, there are a number of things you want to cover while you're there. One of the things that we always recommend, because one of the reasons you're closing a case by settlement is that you want to get it closed. You don't want things lingering. So what we'll do is have the claimant testify at the hearing that he wants to waive his appeal period. Normally, in any case in Pennsylvania where there's a judicial decision rendered, you're going to have 20 days to appeal. You have the claimant waive that appeal period so that as soon as the judge issues their order approving the settlement, you can get your payments out, get your checks out, everyone can close their files. That's usually not a problem, but you'll sometimes need to remind the claimant's attorney to cover that with his client, or ask yourself if necessary.
Many times the employer will have an issue about wanting the claimant to resign. Is that something that's handled in the context of a CNR hearing?
So it's handled in the context of a CNR hearing, though it's not specifically part of the CNR hearing. Our recommendation is, in almost every case, every situation can be different, but as a general rule, you want to get your claimant to sign a resignation, or if your company has a release, sign that release along with the CNR paperwork. The reason being is pretty obvious. You don't want them getting a lump sum and then coming back to work the next day, and then they can file another claim, etc. So you want to make sure you get that executed at the hearing before you get in front of the judge and the settlement's approved. That's something that happens the morning before or the day before or what have you, but you get it in hand ahead of time. It is not part of the settlement paperwork. Workers' compensation judges do not have jurisdiction over employment issues, only workers' comp issues. So that's kind of taken care of on the side. You don't submit it to the judge, you don't mention it in front of the judge, but you make sure you have it. So that is an important aspect.
What happens when the executed agreement is completed? Is there any other steps associated with it?
Well, again, a lot of Pennsylvania is knowing what your judge wants, because it's not uniform. So in the majority of cases, you're going to take your executed paperwork back and send it to your client as a courtesy so that they have it as soon as you have it. But then you're going to wait for the judge to issue his official decision approving it. That usually just happens. The judge will just churn out his order, and then you'll get it in the mail or on Wickus, and you're done. You can pay on it and close your file. However, as most of you know that deal with Pennsylvania workers' compensation, there's now an online filing system referred to as Wickus, and certain judges require either party to come back and upload the actual executed agreement into Wickus before they issue their decision. So if you don't know that about that judge, you're going to wonder, where's my decision? But that's what they're waiting on you to do.
One of the questions I often get from carriers is how much time do I have after the judge issues a decision to make payment to the claimant and the claimant's attorney? What do you typically say to that?
Well, I mean, penalties, as you know, are assessed liberally in Pennsylvania for a variety of issues, so you don't want to be late on your payment. So 30 days after the judge issues his decision, payments are due. There are judges in Pennsylvania that will tell you that the law really says time effective or immediate payment. I think the rule is really 30 days. I'm not sure how you view that, but
yeah, there's actually no case that you can find that says 30 days. The case law says it's immediate. What the practical matter is that if you pay within 20 to 30 days, no judge typically will give you a hard time for a future penalty.
So long story short, when you have the order, if the appeal period's been waived, it's time to process payments and get them out, and then you don't run into that problem at all.
Right.
So we've covered, the document that you need to memorialize your settlement. We've talked about the process to getting it approved. But Chris, what kind of mechanisms are there in Pennsylvania to actually get cases settled?
Right. So when the law changed under Act 57 in 2006, and the CNRs were created, as part of that change in the law, the concept of mandatory mediation came into being. And mandatory mediation is in effect now in Pennsylvania in every litigated case unless it's deemed futile. And what mandatory mediation is a conference between the claimant, the claimant's attorney, the employer's representative, and a workers' compensation judge who is not the adjudicating judge. So when you go in to get your trial schedule on a petition, the adjudicating judge will give you a mandatory mediation date, and you are required to attend and have your client attend either in person or by telephone. You have to do this. You have to attend unless it's deemed futile. And the definition of futile, again, depends on the judge, but even in situations where the employer doesn't have any authority to settle the case, many workers' compensation judges are deeming that as being not futile, that they'll still require you to show up and talk about resolution of the case. The other aspect of it is called voluntary mediation. So under Pennsylvania, we can do this mandatory mediation. We also have the ability to do voluntary mediation, where you and claimant's attorney agree on a workers' compensation judge to listen to your case. In many cases, this is very effective for larger employers and carriers because we can do wholesale settlement days with one workers' compensation judge. The selection of a mediating judge is critical in the context of a voluntary mediation because sometimes it's all case specific, and sometimes you want that really aggressive judge to take control and really emphasize to the claimant what their case is worth. Many times claimants have an unrealistic expectation of what their case is worth, and it's really important that you have an aggressive judge in the context of a voluntary mediation to really hit home what the value of the case is so that you can effectively resolve it. Jeff, what is the significance of superseediest fund reimbursement in the context of a CNR, either agreement or hearing?
Okay, so while you're negotiating your settlement, there are some avenues that are available to you that you can use to reduce your exposure through the settlement process. Now, one of those is superseediest fund reimbursement. So the fund is obviously a fund of money that is paid for through employers in the state. It's available usually when you've filed a termination or suspension petition while you're paying someone wage loss benefits. Your superseediest request is denied, and then you win at the end of the case. Well, you've been paying them this whole time while you're litigating your petition. You can get that money back from the fund. So how do we use this in the context of a settlement? Well, let's say the employer has a pending termination petition. Superseediest has been denied, so we're still paying them total disability. And we've taken our evidence. We've taken our doctor. We have a doctor that says he's fully recovered, so we have our threshold burden of proof right there. We go to a mediation, and we reach an agreement to settle the case. Well, one thing you can do is agree with the other party that the termination petition is going to be left open for a decision with the judge, and it's going to be uncontested. So when you go in for your CNR hearing, you won't have the judge amend your termination petition to a CNR. You'll say, Judge, we're keeping this open. Here's our evidence. The claimant does not have evidence and won't be contesting this. And then you'll proceed with your CNR. So benefits will stop that day based on your settlement, but presumably in a few weeks you'll get a decision from the judge and it will grant your termination petition, and you've now won a petition and you can file for a request with the fund to get your money back. So that's a way of kind of cutting costs down.
Right. But this isn't an ironclad rule. Keep in mind that some judges take a very adverse position against doing this. So you have to know your judge and whether the judge will agree to this. Also, it's going to depend on how much of the termination or suspension petition has been litigated and fully realized. If you have a termination petition where you just present medical and the claimant doesn't present medical and the claimant doesn't testify, it might be a harder situation to get superseediest fund reimbursement versus a situation where everything is all out there and it really appears that this is a contested case. So it's important to know the judge, and it's also important to know the context of the case to get it in front of the superseediest fund people, because they have the ability to deny your request and they will just shoot you back in front of another workers' compensation judge. So it's an avenue. I think it's a very effective avenue, but it's not an ironclad situation.
Right, and Chris touched on the main point of this. You need to know who your judge is at the time you work this into your settlement, not when you go to the hearing and find out they're not going to accept it because you may have budgeted that reimbursement into your lump sum that you're paying. If you're not going to get that back, that can make a huge difference. So you need to know that up front.
Jeff, many times what we do is we settle past, present, and future indemnity, and we try to settle past, present, and future medical benefits. Are there any situations that come up that it implicates Medicare?
Yes, absolutely. Medicare's regulations are actually quite vague, and they're not hard and fast, and so they kind of leave everyone guessing as to what they need, at least educated guessing. So what their policy suggests is that you need to consider Medicare's interest in every settlement. This is not a hard and fast rule, but if you want to follow the letter of what their policy says, you may want to think about when you settle a case for, let's just say, $50,000, we're going to put $5,000 or $10,000 allocated towards future medical to consider Medicare's interest. Then you've gone really over and above. You've done everything you could do.
But the claimant will still get the whole amount.
That's correct. You're still issuing the same amount, but you want to be clear with if that's something you require in your settlements, that your attorneys know that and they're negotiating that way with the claimant, or they can be a little thrown off when that's in the paperwork. It's not all up front.
Are there situations where you're going to have to formally go to Medicare to seek a set-aside proposal?
There are. The reason this is in place is because Medicare doesn't want the workers' compensation system, which would otherwise be responsible for paying work-related medical bills, settling out a claim and then essentially unloading the burden of this person needing a lifelong of medical care onto Medicare. That's the reason they do this. So if you are Medicare eligible and your settlement's over $25,000, you're going to need to get CMS approval of a Medicare set-aside, which the set-aside is basically done as you will obtain a proposal. The proposal will look at the medical facts of the case and will come up with a number that they think is fair for this person to need for monetary medical costs for the remainder of their life. You will then need to ship that proposal to CMS and have them approve it. That number can be what you propose, or it can be more. It's rarely less, if ever. So know that your proposal is not the final word on this if you need approval.
And I would say that these Medicare set-aside situations are very complex. They're sort of beyond the scope of this seminar, but keep in mind that Medicare is always out there. Their interests should be considered in every case. And sometimes you're going to formally have to go and get approval.
And right, and just so I've covered kind of the basis here, if someone has a reasonable expectation of eligibility and it's over $250,000, then that's another case you may need approval. But when you do and don't need approval is pretty complex. So again, it's going to depend on your facts. Right?
The next topic is sorry, Jeff.
Well, I think just one more thing to cover with Medicare is what do you do when you need approval and you want to get your settlement taken care of today? CMS, if they need to approve something, I don't think they're as bad as they used to be, but they're still going to take some time. Well, what you can do is get your proposal. That'll give you an estimated amount you're going to be paying. You can formalize the rest of your settlement, go before the court, settle your case, but put language in your CNR that says we're going to retain the right, we being the employer or a carrier, to either fund the set-aside in the amount that CMS ultimately approves, or if they come back with some astronomically high number, we're just going to leave medical benefits open and we'll deal with it from there. So that way you're not stuck waiting for federal government to kind of decide what it wants to do.
So the next topic is resignation and employment releases. And we talked about this before, so I can really briefly summarize it. One of the things that we typically look at is obtaining a resignation and or a release, and we think that's ideal in any settlement. Jeff mentioned it before. We don't want that claimant to show up the next day after receiving a large settlement and show up at the place of the employer and say, here I am, hire me. So when we do the resignation, typically we write it up as a resignation / agreement not to seek rehire, so as to prevent the claimant from returning back to the time of injury employer. We typically don't submit this to the workers' compensation judge. Some judges become actually infuriated if they see that, so we're very careful about that. And depending on the type of employment, resignation may cost some additional consideration. Typically, it's not a lot of money, $50 to $100 in some cases. I had one case where I represented a hospital system, and the person was a X-ray technician, and because of their geographic location, it would prevented them from really returning to anywhere in the county. That was a situation that required extra consideration. It's typically paid by the employer, but in most cases, it's not an additional amount of consideration even over and above the money that's paid on the CNR.
So another way that you can settle claims in Pennsylvania is without an admission of liability. So you may have a denied claim. You denied it from the outset. You're litigating a claim petition, perhaps, and it's been going on for 9 months, and the claimant has been generating medical treatment and bills left and right. Well, if you want to settle a case with no admission of liability, you're basically going to just settle it without admitting any fault or injury, and the claimant's going to take care of the bills themselves, and that gives you kind of peace of mind to know a huge bill isn't just going to pop up at some point.
Subrogation. What happens in situations where the claimant may be contemplating a third-party case or actually has a third-party case going?
Well, one of the paragraphs in the CNR asks the employer or the carrier if they would like to waive the lien. General rule of thumb is don't waive it unless you're specifically negotiating for a waiver of it. But in some situations, if there's already been a third-party recovery or there's about to be, you could probably settle your case. You could settle your case for a zero sum with just the waiver of the lien being the consideration for the settlement. So something to keep in mind, but you don't want to be waiving it unless you know what you're waiving it for.
Oftentimes, when we settle a workers' compensation case via CNR, we encounter issues with the claimant being the claimant having child support obligations. And all settlements must provide proof that there are no child support arrears. This is called Act 109. The claimant is required to submit Act 109 documentation as part of the compromise and release settlement that gets attached to the CNR, and the judge is required to look at that as part of the case. If there's no Act 109 documents submitted, the judge will not approve the compromise and release agreement. And typically what these documents are provided by the claimant's attorney, although we, the defense, will go and run the Act 109 documents through the child support website to make sure that they're accurate. In the event there are liens, the employer will need to satisfy them directly from the settlement proceeds, and arrangements can be made with domestic relations to alter the amount paid from the settlement. The key thing to keep in mind here is that every domestic relations office, it works a little bit differently. So the Philadelphia office works differently than the Harrisburg office, and that's different from the Pittsburgh office. So when it comes to the child support arrears and what you can and can't pay, it's important to know that there is an arrears ahead of time and check with the local domestic relations office to make sure that you satisfy their local rules.
So some just issues that you want to keep in mind anytime you settle a case in Pennsylvania. Generally speaking, specific is better than general, and that means going into your settlement. You want to be specific about the medical bills that you're going to be paying in your settlement. Is it just related to your accepted injury? Is it related to one of two alleged injuries? You need to be clear, or that settlement's binding and whatever's in there can obligate you to pay certain things that you may not have intended. You want to be careful about what the injury is you're describing, again, because it can obligate you to pay for medical bills that you may or may not want to pay for. You want to be clear that you're resolving all injuries this person had while they worked for you. You don't want settling one claim out and then someone filing a reinstatement on an injury from 10 years ago. So you put all injury language in there. You want to make sure any offsets or credits that you may be entitled to for unemployment or short-term disability, whether those are taken care of. So you also have to look out for, when you're settling a case, there's going to be counsel fees and litigation costs. Are you including that in your lump sum, or is that over and above? Make sure you're clear on that. And then finally, if you're resolving it full and final, you want to be sure it is full and final. You don't want to leave a penalty petition hanging out there, or some claim for unreasonable contest, or something like that. You need to make sure everything is wrapped up.
Or if there's something on appeal, you want to make sure
Right.
that the parties will withdraw their appeal maybe in front of the Commonwealth Court or the WCAB to make sure that everything is taken care of in the context of the CNR. Well, so that is the end of the presentation today. I'd like to thank you for attending. We do have some upcoming programs that are listed in the materials for WG University, so you can feel free to look at those. Our next one, for example, is April 19th, and that is one from New Jersey, which covers why does New Jersey workers' compensation move so slowly? So that'll be presented by my partner, Jeff Newby, and that should be a very interesting one. We also have another one coming up. I think if you could flip the next slide. Yeah, and that's another series in August, September, October. So basically the idea is to check with our website to make sure that you are updated as to what is coming up next. And finally, we have an upcoming event in Philadelphia on April 6th, which concerns the rights of the LGBT community in the workplace. And this is part of our employment law series. I encourage everyone to follow up with this to see if they want to attend. It should be a very dynamic presentation. We have some representatives from the local government and the state government as part of the program. So with that, that concludes our time. And again, thank you for attending.
Thank you.